All right, everyone. I'm going to call the docket. And so this is going to be the order of things this morning. We have a jury trial. They're doing closing arguments this morning. However, if all the jurors are not here, then of course we'll take up any matters that we can take up before the jury arrives. So each side is going to have 40 minutes. So attorneys, you'll know how to schedule your time. All right, when I call the docket, please stand and let me know you are here. Gustavo Jimenez, custody. Jamar Clark. Pedro Rodriguez, custody. Vincent Arredondo. Adam Herrera, custody. Ryan Jordan Westbrook. Ryan Jordan Westbrook. Christopher Bernal, custody. Roman Flores. Denny Logan, custody. Tammy Marie Franks. Juan Rivas. Thank you. Mahmoud Algadrop. Edward Castillo. Edward Hernandez Castillo. Johnny Galvan, Malik Lampkin, custody. Michael Sanchez, custody. Mark Log, custody. Vincent Arredondo. Taboris Warren. Taboris Tremaine Warren Jr. Joshua Casey. D'Artagnan Nathaniel Rinson. Thank you. Brian Warley, custody. Kevin Trejo. Kevin Luis Trejo. Samuel Allen Bach. John Thurnert. Eric Cooper, custody. Christopher Guerrero. George Abaye, custody. Daryl Payne. Hi, Mr. Payne. All right, how are you doing? All right, you're looking great. All right. Is there anyone present whose name was not called? Or you came in late? Yes, sir. I'm sorry, ma'am, what's your name? Franks. All right, we have you. Anyone else? All right, Deputy Laura, all the jurors here? Okay. All right, then can you all bring out Robert Featherston's client, Mr. Allen, because all he has to be is sworn in. And who's your?
Can I meet briefly with Gustavo Jimenez, Judge?
And Gustavo Jimenez. Sorry, actually.
Oh, yeah. Sorry.
Are you?
Yes, ma'am.
All right, State Defense, did you all have what time announcements?
Yes, Your Honor, the state could get just a 2-minute time announcement at the end of the arts for our time.
I'm asking. 2 minutes, okay.
Yes. Oh, you're fine.
Your Guerrero.
Your Honor, can we confirm the time that we have per side?
5 minutes. Now you all agreed to 20 minutes.
Thank you, Judge.
Sure. You guys like, what? 5 minutes? How do we split it?
Rick gets 30 seconds. Yes.
Hello, good morning.
I didn't say negative. I did think you're like, I was 4 minutes.
You again. Gotta get on the tie. What's this? Do closing there, so. With the trophies. Yeah.
So my great niece has received her teething. She has
She would call.
4 teeth. She doesn't know what to do with them.
Does she have to wrap?
Yes. So it was delivered yesterday. So she's getting the back of the gums. I can't even imagine.
Child, which one is that?
Oh, it's my great niece.
Oh, so not the one that's 3.
No. Oh, no, her teeth are in.
Yeah.
In the case that I had, though they were in uniform, they didn't identify themselves as that. And he thought that he was outside on his family was firing shots all over the
So if he's moving or so, or he's so that he also he should have. But that that's one that I'll go, but what if the officers can or necessary. Yeah.
It could.
All right.
I mean, the jury sort of had to say that if you do what you did, and that they it's usually force. And reasonableness is you could say that you know the law enforcement officer put there and put him in here for his own sake.
Yeah.
Then you or you are against their confidence. That could lead to
Okay.
Yes, what do you want to do?
We see the fault in this. Fire. Fueled.
I'm glad to serve.
well, the SOP, for those type of situations is but it's not all possible. It's convincing the jury that law enforcement will not use that sensor. And then, if it wasn't reasonable, then we'll talk about, the state is unable to disprove this defense juries beyond the reasonable doubt.
Yeah.
And then, getting them to agree to a very strict reasonable doubt definition of themselves. You know, you can't ask for a definition
Yeah.
anymore, but.
Yeah.
Yeah, they don't have like mine, but you can certainly, because it's a federal motion of evidence. You can talk about their consumption.
Right, how it's very, like you said. That levels of examples and stuff like that.
Yes.
I'm conferring with the DA. Then I'm gonna head over to another court real quick and do a plea and I'll be back.
Okay.
Okay.
All right, thank you.
What are you doing? Okay, good.
I can answer, but I thought. How long do you want to ask you? All right, I can ask. And then you'll get the urgency.
Still missing one? Okay.
Yeah. Yes.
All right, Roman Allen Flores.
Morning, Your Honor.
Good morning. So how did it go?
I feel much better today.
All right, no cavities?
Well, they had to take a bunch of stitches out from over. And so it's still a little bit tender, but I'm not as distracted as I was after.
Ah. All right, the court is calling 2025 CR 002-317, State versus Roman Allen Flores. Can I have parties announced, please?
Duffy Pitlock for the state of Texas, Your Honor.
Robert Featherston representing Mr. Flores.
And are you Mr. Flores? Counsel, have you received all discovery and did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Is there any application?
No, Your Honor.
All right, Mr. Flores, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Your Honor, we are not exactly, I hope it's not terribly complicated. We have the one cause number ending in 317. There were 3 counts.
Yes.
So we are proceeding on count 1 and count 3. We are waiving and abandoning count 2, but because they are different punishment degrees, there's different sets of paperwork in front of the court.
All right. And are you waiving the enhancement or no?
Yes, Your Honor, the statements.
Any objection?
No objection, Your Honor.
All right, Mr. Flores, did you review the admonishments and waivers with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places? Right. So in, just one moment. And count 1, you're charged with evading arrest, detention with a vehicle. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. And count 3, you're charged with theft of property, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea, and gives you more than you bargained for. The fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. Did you understand?
Yes, ma'am.
By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
In each of these counts?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as the factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is.
Mr. Flores, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
All right. In each of the pleas, the state is waiving and abandoning the repeat enhancement paragraph and count 2. In the state jail felony, they're asking that your punishment be assessed at 119 days in the Bexar County Jail under 1244. There's to be restitution, if any, payable to Javier Leonardo, and there's to be no contact with him. And count 1, the state is asking that your punishment be assessed at a cap of 10 years in the prison. There are no applications. This case will run concurrently with the other count. So they're asking that the counts run concurrently. And they are asking that there be a judgment satisfied in 2025 CR 002317, and that is count 3. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
That is, Your Honor.
State is at the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
No.
Counsel, have there been any such motions?
No, Your Honor.
Then to count 1, how do you plead? Guilty, not guilty, or no contest?
Guilty.
To count 3, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
State offer states exhibit 1 in all attachments at this time, Your Honor.
No objection, Your Honor.
All right. Did you review the waiver and consent to stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right. After reviewing State's Exhibits 1 and attachments in each count, the court will find there sufficient evidence to find you guilty, and the court will find you guilty of each count. Counsel, let me write this down. All right, counsel, it takes 8 to 12 weeks for a PSI, but if you would like to just have this come back sooner and have me give you a shorter date and you can call your witnesses, I'll ask the state for any criminal history to be given to me at that time.
Your Honor, could we ask for 4 weeks?
Yes. All right, I need a 4-week reset. And are you waiving the PSI?
We are.
All right. Ms. Abrams, no PSI. All right, so we can go off the record. This is what's gonna happen on September 9th. The state will present witnesses if they have witnesses for the court. If they do not have witnesses, the only thing they're gonna present to me is your criminal history. They'll present that to me. And then your attorney, if you all wish to have witnesses for me to hear from those witnesses, I'll hear it at that time. And then I'll base my decision upon whatever evidence is presented to me. The evading, since the offer is a cap of 10, I can sentence you anywhere from 2 to 10 years in the prison. And with the other cause number, if I'm following your plea bargaining agreement, then it will be a judgment satisfied under that count. Do you have any questions? All right, thank you.
That be the TSC case?
Yes, I'd like to do it at that date.
That's fine. Judge, thank you for your time.
You're welcome.
I didn't date it, so we'll fill it in.
Oh, yeah, that's fine.
There's no PSI. Yes.
Order to the court, Your Honor.
Good morning.
Sticker on watch. Sticker on watch. You're live in person.
Mm.
Yeah, I'll go back.
Who's here on Gustavo Jimenez?
Present, Your Honor.
Good morning.
Judge.
Hi. So where is he?
He's currently sitting right here in the box.
Oh, come forward.
You can come forward. Puedes venir acá, you know.
Hello.
Good morning.
Good morning. How are you doing today? I'm so sorry. Our Odyssey, of course, who knows? Some days it's working, some days it's not. Today, it looks as though it is not working.
There's some lag. Sorry, Your Honor. I've viewed it just as soon as yesterday evening. I agree. There's been a bit of a lag. In my opinion, there's also been a little bit of a lag with the Bexar County e-discovery system.
Mhm.
So I'm still waiting some of those reports to be downloaded with those videos. My client here, Mr. Gustavo Jimenez, was deemed restored to competency July 24th, Magistrate Court Judge Rodriguez. Prior to that, he was at the Kerrville State Hospital for a year under that order of incompetency. So he's recently restored, Your Honor. This matter was brought back here recently from the MAG court. But we're requesting a discovery hearing reset date, Your Honor, for me to be able to go into that. And I know the state is seeing where they're at with contact in terms of the complaining witnesses. This matter could potentially be set for August 26th, Judge. I'll be here on some other cases.
All right. And is he still on his medications?
Yes, Your Honor. Yes, Your Honor.
All right. How are you feeling? Oh, that's good. So what we're going to do is we're going to call you back on August 26th. And that's to make sure that your attorney has all of the discovery he needs for your case. All right. Do you have any questions about anything?
No.
All right. You're looking better. All right. So what's going to end up happening? They'll take you back now Unless defense, you have more questions for him.
Oh, no, nothing further, Your Honor. We explained things and we follow up with the visit shortly in advance of the next court date.
All right, thank you. Thank you.
Have a good day.
Oh, you too. All right, Daryl Payne. Hello, Mr. Payne.
Yeah, definitely good.
And you're looking great. How are you doing?
Losing weight.
Oh, are you trying to lose weight?
Trying to put some on.
Okay,
But
well,
it sounds like a Holocaust.
no, you do not. Well, this is what I want you to do. If you feel that you're losing weight and you're not trying, you probably need to go see a doctor to see if there's something going on.
Yes, ma'am.
Okay,
Yes, ma'am.
so make sure you get a doctor's appointment to address that, okay?
Yes, ma'am.
All right, how's he doing?
So Judge, I spoke with Mr. Payne's brother and he's been doing well. He's working with the behavioral mental health personnel. A nurse came out to see him on the 1st. They're just trying to get him established with his shot.
Okay,
And they're trying to make progress in obtaining the approval to get the shots. So they are working on that. He is going to see his primary care physician in regards to his legs. They're pulling off, I believe, they said a lot of fluid. So
Yeah.
that's going well. He doesn't really go anywhere at this point. His brother doesn't feel necessarily comfortable with just letting him just, roam about.
Mhm.
So he's been staying at home pretty much. But he also said that he doesn't want to go downtown or anything like that, so he's content at this point. He has a probation appointment on the 19th. He is aware of that probation appointment.
You mind if I get a card?
That's PDFs.
oh, a card?
For my probation officer, a card and the time that
Take a look at it right now.
I'm supposed to be here.
I can write that down for you today.
Yes, we'll make sure that you
Yes,
have that,
ma'am.
okay?
Yes, ma'am.
So as of right now, everything seems to be good. I did ask Mr. Payne if he's doing his chores around the house. He said no.
I'm gonna try.
But his brother said that he's gonna work with him on that and compromise between the both.
I'm studying Bible.
Not like.
Oh, that is awesome.
The
Do you
Bible.
have a, Norma, excuse me, can I get one of these blank notebooks?
I don't like those guys.
I told them.
And I think that's about it. Mr. Payne, did you have any, you wanted me to come back?
I've been feeling kind of drowsy and moody, but the medication is making me feel moody.
Okay,
Yes.
all right, so here's the thing, if the medication is giving you some sort of side effect,
Yes,
you
ma'am.
need to let your doctor know, okay?
Yes, ma'am. It's making me moody.
Okay,
Yes, ma'am.
And he also, Mr. Payne's brother just said that he has a follow-up appointment on the 12th for his legs. So right now, I think everything is going as planned. There are certain steps that still need to happen, obviously. But he's in a good spot right now.
I'm learning to appreciate my brother, Stephanie. Without him, I don't know if I can make it.
oh,
Yeah.
well, that's good.
Yeah.
All right, so this is what I'm going to do. Here's a tablet, here's a pen,
Yes, ma'am.
and you can put your notes in there and you can put your thoughts down if that's what you want to do, okay?
Yes, ma'am.
Hard.
I'll try to do that.
All right.
Thank you, Stephanie.
You're welcome. And then Miss Abrams will be able to write appointments
Yes,
down
ma'am.
for you, okay?
Sorry I came moody. The medicine is not agreeing with me. There's a lot of pressure in the back of my head too.
Get the
Okay.
next to notify the nurse that's been coming by.
Okay.
Thank
Um,
you, Stephanie.
Oh, you're so welcome.
You have a pleasant afternoon.
Right. So just one second. I want to make sure that we get another status here with you to make sure the doctors are taking everything, okay? When do you want?
Compared to other ones.
All right. Let's do a 45-day. I need a 45-day reset.
Yes, ma'am.
He didn't get the key, he didn't even get the key.
All right. Ask his brother if September 18th is good for him.
Mr. Payne, is September 18th good for you?
He's pretty extensive.
All right. So we'll come back on September 18th and that's to see how you're doing, okay?
Yes, ma'am. Thank you for being nice, Stephanie.
Oh, you're so welcome. You were not moody to me today.
Just
All I
hope-
wanna do is just.
The medicine, Stephanie, I'm telling you that medicine ain't agreeable.
All right.
I've been changed on so many
Take him
different
to the state
medicines.
jail.
All right.
And
So talk to,
for
make sure you, however you're feeling with the medication, put the notes down. I have to do it too for me when I'm on meds. I put the notes down so they'll know how you feel. And then if something is not agreeing with you that you're eating, just write everything down so you can let the doctors know when you see you. Okay.
Problem.
All right. Thank you.
I have everybody in line, Judge, everybody's here.
All right. Thank you. All right. I'm going to take this one matter up because it's um, oh, and Norma, make sure he has this reset form.
Judge, I already called IT also because the monitor keeps on going in and out.
Yeah. Bye-bye. Oh, don't leave yet. They're going to give you your reset form, okay? All right. And Miss Abrams, you have Christopher Anthony Guerrero?
Yes, Judge.
Hello. How are you doing?
Great, how about you?
Oh, I'm doing good. I cannot complain.
That's good.
I'm currently alive. That's always a good start.
That's all that matters.
So Judge, this compliance hearing is regards to a referral outcome we received from felony drug court. Felony drug court said that Mr. Guerrero met the criteria, but he was rejected because he's not willing to participate in the program.
Mhm.
But, Mr. Guerrero wanted to explain to the court why he doesn't necessarily want to participate and how he's come along on his probation thus far and what his plans are.
Yes.
Yes, okay, so, they, were telling me if I were to sign, right? I would have to, because I worked every day, right, 8 to 6, 8 in the morning to 6, and they said Monday I would have to go meet up with them at 8 in the morning, and Tuesday I would have to go meet up with them at 1 p.m. and then call every day. They said wherever I'm at, I would have to leave there within 2 hours. I have to go do UA,
Mhm.
right, wherever I'm at. And this job, it's a new job that I started, you know,
Mhm.
and I'm the head household. I'm paying everything, and for me to risk that, you know, like they said you would have to put this first out of everything, you know, need your job or anything. And I told them, is there a way to like work, like, you know, work away, you know, like around it? They're like, well, there will be another opportunity. They were saying there will always be another job out there. I was like, well, I'm paying the bill right now.
Mhm.
not that I don't want to, I like the way you guys work, to help people out and stuff. I've been sober for 9 months. I've been my probation officer, man, like we communicate so well. I've done so much already. I've done my GPS, I've done my parenting classes, I've done, what else? Outpatient, I've done,
So what are your thoughts?
Judge, I think, at this point, he's on monthly UAs. All of his UAs have been negative. He has completed sober outpatient treatment. Supportive outpatient treatment. He's made great progress in all of his classes. At this point, I think we just, continue with monthly UAs and, just, supervise.
Has he been doing his sober support meetings?
yes, every day. My probation gives me the papers
Mhm.
and write it down every day. And today I do it 5:30,
All right, so here's the thing. Whether or not you end up in that program is going to be completely up to you. You need to make sure that you maintain your sobriety, you understand?
Of course, yes, ma'am.
All right. Is there anything else you need from us?
No, just remain on probation.
Yes, I'll remove that condition. All right, thank you.
Do you want to remove or just hold it in abeyance?
No, we'll remove
Remove
it.
it? Okay.
Yes.
Thank you, Judge.
Hi, thank you. Hey, how's it going? You're looking fantastic, sharp. Where are you going?
Commissioner's Courts today.
Oh, that's okay. We're going to start because we don't have time. So we'll see if it works.
Going off and on?
Yeah.
I could do it real fast. And you can go to-
Okay, sure.
Take care, Judge.
All right, you too. All right, the court is calling 2025 CR 002807 State versus Angel Miguel Cepedas Rhonda. Could I have parties announce?
Ashley Johnson, representing for the state.
John Reitmeyer for the defense.
And are you Mr. Rhonda?
Yes.
All right, the interpreter who's here has been previously sworn. Both parties, you had a chance to review the charge of the court?
We did, Your Honor.
Any objection?
Not from the state?
No, Your Honor.
All right, so we can go off the record for a moment. Everyone, you need to make sure that your phones are on silent or on vibrate. There's nothing worse for an attorney when they're in the middle of their argument, they've hit their groove, and all of a sudden a cell phone goes off to distract them. So make sure your cell phones are on silent or either vibrate. All right, so each side, you've agreed to 20 minutes, and each of you are asking that the court give you a 2-minute warning, correct?
Yes, Your Honor.
That's correct.
All right, let's bring the jurors in.
All right, for the jury.
All right, everyone, please be seated. So ladies and gentlemen, there are other people in the courtroom. They are not related to this case in any way. I just have a morning docket. So I'm going to read to you what is called the charge of the court. It's the jury charge. You do not have to memorize this because you will be given the original when you begin your deliberations. All right, charge of the court. Members of the jury. The defendant, Angel Miguel Cepedez Rhonda, stands charged by indictment with the offense of aggravated kidnapping alleged to have been committed on or about the 4th day of May 2024 in Bexar County, Texas. To this offense, the defendant has pleaded not guilty. 1, our law provides that a person commits the offense of aggravated kidnapping if he intentionally or knowingly abducts another person with the intent to inflict bodily injury on that person or violate or abuse that person sexually, or he intentionally or knowingly abducts another person with the intent to terrorize that person, or he intentionally or knowingly abducts another person and uses or exhibits a deadly weapon during the commission of that offense. 2, abduct means to restrain a person with intent to prevent her liberation by A, secreting or holding her in a place where she is not likely to be found, or B, using or threatening to use deadly force. Restrain means to restrain a person's movements without consent so as to interfere substantially with the person's liberty by moving the person from one place to another or by confining the person. Restraint is without consent if it is accomplished by force, intimidation, or deception. Deadly force means force that is intended or known by the actor to cause, or in the manner of its use or intended use, is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. 3, a person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 4, now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 4th day of May 2024 in Bexar County, Texas, the defendant, Angel Miguel Cepedez Rhonda, did intentionally or knowingly abduct another person, namely Duvila Contreras Perez, with the intent to inflict bodily injury on Duvila Contreras Perez or violate or abuse Duela Contreras Perez sexually or with the intent to terrorize Duela Contreras Perez by restricting the movements of Duela Contreras Perez without her consent so as to interfere substantially with Duela Contreras Perez's liberty by confining her with the intent to prevent Duela Contreras Perez's liberation by secreting or holding Duela Contreras Perez in a place where she was not likely to be found, or with the intent to inflict bodily injury on Duela Contreras Perez or violate or abuse Duela Contreras Perez sexually or with the intent to terrorize Duela Contreras Perez by restricting the movements of Duela Contreras Perez without her consent so as to interfere substantially with Duela Contreras Perez's liberty by moving her from one place to another with the intent to prevent Duela Contreras Perez's liberation by secreting or holding Duela Contreras Perez in a place where she was not likely to be found, or by restricting the movements of Duela Contreras Perez without her consent so as to interfere substantially with Duela Contreras Perez's liberty by confining her with the intent to prevent Duela Contreras Perez's liberation by secreting or holding Duela Contreras Perez in a place where she was not likely to be found, and Angel Miguel Cepedez Rhonda used or exhibited a deadly weapon, namely a pair of scissors during the commission of the offense, or by restricting the movements of Duela Contreras Perez without her consent so as to interfere substantially with Duela Contreras Perez's liberty by moving her from one place to another with the intent to prevent Duela Contreras Perez's liberation by secreting or holding Duela Contreras Perez in a place where she was not likely to be found, and Angel Miguel Cepedez Rhonda's used or exhibited a deadly weapon, namely a knife, during the commission of the offense, then you will find the defendant, Angel Miguel Cepedez Rhonda, guilty of the offense of aggravated kidnapping as charged in the indictment. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the offense of aggravated kidnapping as charged in the indictment. 5, if you have found the defendant, Angel Miguel Cepedez Rhonda, guilty of the offense of aggravated kidnapping as charged in the indictment, you are instructed to make a separate finding of whether the defendant used or exhibited a deadly weapon, to wit, a pair of scissors and or a knife during the commission of the offense. Deadly weapon is defined in paragraph 2. Therefore, if you unanimously find the defendant, Angel Miguel Cepedez Rhonda, guilty of the offense of aggravated kidnapping as charged in the indictment, and if you unanimously find from the evidence beyond a reasonable doubt that Angel Miguel Cepedez Rhonda did use or exhibit a deadly weapon, to wit, a pair of scissors and or a knife that in the manner of its use or intended use was capable of causing death or serious bodily injury during the commission of the offense of aggravated kidnapping, then you will so state in your verdict. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will so state in your verdict. To ensure that the jury, the court, and the parties are all receiving the same testimony, whenever a party or a witness does not speak English, the services of an interpreter are employed. You are instructed that you, as the jury, are to base your deliberations on the questions as they came from the attorneys in the English language and the responses from the witness as they came from the interpreter in the English language. You are instructed that under our law, voluntary intoxication does not constitute a defense to the commission of a crime. For the purpose of this law, intoxication means a disturbance of mental or physical capacity resulting from the voluntary introduction of any substance into the body. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by witnesses to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You're instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You're instructed that you are not to let bias, prejudice, sympathy, or number of witnesses called by either side play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge. Just one second. Who has the phone? Right. Just one moment. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony. But you are bound to receive the law from the court which is herein given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict. But jurors have a duty to consult each other and to deliberate with a view of reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove its innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. Are both parties prepared to proceed?
Yes,
Right. All right, jurors, before I turn it over to the state for their closing arguments, do any of you need a break? All right, state, you may proceed.
Morning, everyone. I want to say thank you so much for your attention during this trial. I know it has been a long trial, but I promise you we're almost done, okay? Now, as the judge said, what she just read to you is called the charge of the court. Those are your instructions that you guys will be following once you begin your jury deliberations, okay? And as the judge mentioned, don't fret if you happen to miss anything, because you are going to get to take an exact copy of what she read to you back to the jury room, and you can read through it as many times as you need to, okay? But what I want to do right now is just kind of go over a few things that clarify some issues that are pertinent to the trial, okay? On the first page that the judge read to you, she says, our law provides that a person commits the offense of aggravated kidnapping if, and then there are 3 bullet points, okay? Those 3 bullet points are the 3 separate ways that we as the state of Texas can prove that the offense of aggravated kidnapping was committed, okay? Additionally, in between the first and second bullet point, and in between the second and third bullet point, there is an or, not an and, or. What does that mean? That means that we as the state are required to prove all 3 of them. We are only required to prove 1 of those bullet points to you beyond reasonable doubt, okay? Moreover, you all do not have to agree together on which of those bullet points has been proven by us. You, ma'am, can believe first bullet point. You can believe second bullet point. You can believe third bullet point. You second, you third. It doesn't matter. So long as all 12 of you believe that at least 1 of those bullet points was proven by us throughout this trial, okay? Next thing I want to go over with you is on the second page. This contains some pertinent definitions that are vital for your deliberations. I just want to make sure we're all on the same page on, okay? On the second page, the judge gave you the definition of restrain. It means to restrict a person's movements without consent so as to interfere substantially with the person's liberty, and then 2 bullet points. By moving the person from one place to another, or not and, or I can find the person. What do those two bullet points mean? First bullet point means you take somebody from one place to another. They don't want to go with you. Okay, simple enough. But the second bullet point means you make someone stay in a place that they don't want to be. Okay, against their will. Again, simple enough. The next definition I want to go through with you is the word restraint with a T. Restraint is without consent if it is accomplished by force, intimidation, or or deception. Force. What have you heard? Defendant used knife and scissors against the victim. Okay. Intimidation. You heard the threats that he made to her. Obey me is what he told her to do. Okay. Next definition I want to give to you is abduct. Means to restrain a person with intent to prevent her liberation by bullet points. Secreting or holding her in a place where she is not likely to be found, or using or threatening to use deadly force. Well, the second bullet point, let me just do that real quick, is that simple enough. You either use force or you threaten to use force. Okay. What the first bullet point means, though, that you don't want this person to go free. You're hiding them in a place away from the public. And they don't want to be there. Okay? That's what abduct means. Next definition I want to go through with you is on the next page. Deadly weapon. Means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Knife and scissors. Again, you heard the victim say that that defendant used a knife and scissors against her. Not only to keep her in the barbershop, but to move her from the barbershop to his car, back to his apartment where she didn't want to go. Okay. Knife and scissors are a deadly weapon capable of causing death or serious bodily injury. As such, once you all begin your deliberations, one of the first things you all need to do is select which one amongst you is going to be your presiding juror, okay? Presiding juror is going to be the person that kind of oversees and guides the deliberations as they're going by you guys. What that presiding juror needs to do, go to the last page that's right here that the judge read to you, where it says, finding as to use or non-use of a deadly weapon. Go down right here. We unanimously find that the defendant used or exhibited a deadly weapon. You check right there, presiding juror signs, okay? The last thing I want to go through with you is intentionally or knowingly. Ladies and gentlemen, this was not an accident, okay? It was that defendant's intent to commit this crime. When I finish here in a minute, defense will get up and he's going to give you his closing argument. Then Ashley's going to finish off with you all, and she's going to deal with some more detailed analysis of how we are proving this crime to you beyond reasonable doubt. What I want to make sure you'll understand, he moved her from bar shop. He kept her there first against her will, moved her to his car, to his apartment, where he brutally assaulted and raped her. Find him guilty of the offense of aggravated kidnapping. State will reserve the rest of its time.
Oh, thank you. All right, defense, you may proceed. Yes.
Good morning. When I was little, I remember a time when my mom bought a new car that was new to her. And I remember this car because of what happened. Specifically, this car, when she bought it, the deep, dark black, just a vivid color, one that you look at and you just remember. She was really, really proud of it. One day in the summer, she hadn't had it very long. I was playing out front of the house with my friend up the street, and we were doing whatever we were doing, getting in trouble and having a good old time. And at some point, and I don't know why, my friend I was playing with, once we were playing in the driveway, he jumped up and jumped on the trunk of the car. And I remember seeing that and saying, hey, get off. My mom is going to get really mad if she sees you on her new car. And he did. A few minutes later, I saw my mom come out carrying some stuff because she was going to go somewhere. and we were still in the front yard. And it wasn't very long after that, I heard my full name, first, middle, last, yelled at the top of her lungs. You remember when you're a kid, if you get your full name called, something's about to go down. Brought me up. She pointed out the trunk of her new car and it had a scratch on it. And I wasn't given a chance to explain what happened. I was summarily taken inside, grounded, not allowed to do anything. And it upset me. But I learned something from that. And it always made me remember that if my mom had done a little bit of investigation, maybe there would have been a different outcome. Because what's worse than being punished, being wrongfully punished? Let's talk about what we've heard over this trial. We've had a story. The story began with an assault. Officers Beatty and Officer Mata showed up and testified that they pulled up to the scene on their response to the call for service. Officer Beatty said he went in one place, didn't see anything suspicious. Officer Mata yesterday told you he didn't go inside anywhere. He stayed out in the parking lot. He walked up and he walked down looking for things that were suspicious. Did either of them see anything? No. The next day, May 5th, we have another call to report an assault. We had 4 officers show up and you heard from one of them, Officer Ruiz. Officer Ruiz testified, we were there for an assault. Was there any mention of a kidnapping? Was there any mention of anything else? No. All that was reported to the officers was an assault. We heard from Investigator Rodriguez, who was the crime scene unit officer to show up to take pictures. What did he testify to? He testified he was able to take pictures of her as he saw her, but he wasn't allowed to take pictures of any other injuries. He offered to let her wait for a female officer to take those pictures, but she didn't take that option. What else did he say? Investigator Rodriguez said part of his job was to take a picture of the scene. Well, think about this. If this assault happened inside a barbershop, wouldn't there be reason to go and take pictures of the barbershop? There are no pictures. None were taken of the scene. Then we heard from Detective Lopez. She got up and said, the case was assigned to me and we reviewed it. Now the detective has a bunch of tools at her disposal to investigate claims, investigate charges. And we asked her, well, after reviewing all this and you thought something happened, did you try to get fingerprints? Nope. Did you try to get a DNA sample? Nope. Did you at least get a search warrant for the barbershop to see where this assault happened? No. Now you think there's another part of the felony, excuse me, and a kidnapping and a sexual assault happened at an apartment. Well, did you get a search warrant for that to go see? No. No, we didn't. Did you request a rape investigation? No. No, we didn't. Did you ask her to at least go see a doctor? No, we didn't do that either. So what was her evidence to proceed with all this? Pictures? If you remember, the report was made on May 5th. Detective Lopez testified she didn't meet with the complaining witness in this matter until May 17th. That's 12 days later. And she got the pictures after that. So it took over 12 days for Detective Lopez to get pictures of the body of these injuries. no one can say that these injuries were actually there on the day of this incident that allegedly happened. Most strikingly, when we asked her about the sexual assault that she says happened, she says, we confirmed the sections. I said, really? And she said, yeah, we confirmed it with a phone call. Think about that. Detective Lopez didn't even make the phone call. It was another person who was assisting her. He picked up the phone. Oh, a sexual assault happened. End of story. That's their confirmation? At some point when the detective was speaking, she said, well, it was coded as a misdemeanor, so that's what we didn't do what we normally did. Well, my question to you is, in the course of this investigation, and you come across some new facts that maybe might be more serious, wouldn't that be a good time to maybe try to get some more evidence? Wouldn't you think? We had a story, and the story got bigger. The story's gotten bigger. Now let's talk about the complaining witness, Ms. Contreras-Pettis. She said she had 2 phones, and one of those phones was for her 4-year-old. Phone for a 4-year-old with a data plan. She said that Angel came into the barbershop and he locked the door. And she specifically said, oh no, he locked it with a key. I want you to think about that. What business has a lock on the front door that requires a key? The answer is none, and there's a reason. Because we don't want people trapped in buildings if there's a fire. There is a specific reason for that. Next, she said, well, he took me outside holding a blade to my neck to the car. And I saw the police out there in the parking lot, but they didn't see me. And I tried to get their attention by waving my hand. Again, think about what the officer said. We're not talking about a parking lot that's 2 miles long. We're not talking about being way out in left field and trying to make a throw to home plate. Officer Moffitt testified these businesses were close together. If there was something suspicious, they should have been able to see it and they would have acted on it. But neither of them said they saw anything suspicious. It would have raised an eyebrow if something like that actually happened. Then Ms. Contreras-Pettis said she had to get into the car. And she testified that Angel kept a blade on her, but he opened the door and she got in the car. Okay. Now, she didn't testify that Angel crawled in through the passenger side to get to the to be able to get into the driver's seat to drive the car. So that only leaves one logical explanation. He had to go around the car to get in. Ask yourselves this: at any time during this sequence of events that's being described, wouldn't that be a good opportunity to maybe get out of the car if you're in trouble? Wouldn't that be a good opportunity to say, hey, police officer, I'm in trouble? Wouldn't that be a good opportunity to just run away? She mentioned she drove with him to his apartment. There are stop signs and stoplights all along the way. She didn't testify he had a blade against her neck while he was driving. Wouldn't that be a good opportunity to get out of the car? Then she testified, we got to the apartment complex, went inside, stood in front of the door and locked the door. She testified, I went to the bedroom and I was going to try to make my way out of a window. I was going to escape. But then later on, she changed her testimony. And she said, well, I was just trying to get someone's attention. I wasn't trying to escape. Then she said Angel pulled her from the window to the bed. But guess what? She changed her testimony again. She said on direct, Angel took her to the bedroom. So which story is it? She said it was a sexual assault. And then she got on the stand and said, oh, by the way, it was also a sexual assault anally. And then her story. The next morning, after all these tragic happenings, Angel walks in after drinking all night. He walks in bright-eyed and bushy-tailed like nothing happened. The story gets bigger and bigger and bigger. All these stories are coming from a lady who had been in a 7-month relationship with Angel. A lady who got a tattoo of his nickname, as she said, not long after they started dating. And I have to ask you, ladies and gentlemen, does any of this make any sense logically or rational? You also heard from Mr. Hernandez yesterday, who knew the shop. He owned the shop. He testified he did the renovations of the shop himself. And he testified, no, there wasn't a key. Did not need a key to lock the door from the inside. And he further testified that he did all the lights and added lights. And there were no concerns about lighting. There were bright LED lights. You remember that? Ladies and gentlemen, you are the sole judge of the credibility of the evidence and the witnesses. Now, I want you, when you go back and deliberate, remember the state's burden. They have to prove every element beyond a reasonable doubt. And you have to be unanimous. All 12 of you have to agree that this offense was committed. Now, Ms. Jones is going to get up here after me and she's going to talk to you because that's how our system works. They get the last word. It's their burden. Listen to Ms. Jones. But as I told you in the beginning, be open-minded, be critical. What makes sense? What makes sense? At the end of this, there's not enough evidence to prove the state has proved their case beyond a reasonable doubt. Now, there's no doubt about this. Y'all have a tremendous responsibility here. But you also have an incredible opportunity. You have an opportunity to send a message to the state of Texas and say, no, not on my watch. The state of Texas is going to bring a case this serious with serious consequences. They better bring their A game. They better bring more than a story filled with inconsistencies about everything and nothing to back it up. Protect Angel. Send a message. Find him not guilty. Thank you.
You're welcome. All right, states, you have 14 minutes.
Thank you, Your Honor. Good morning. Dubiella didn't want to be held in that barber shop with scissors and beaten. She didn't want to go to the defendant's car, and she didn't want to go to the defendant's apartment. She didn't want to be raped. But she had to because he literally had a knife to her throat. He threatened her son by threatening to take her away from him. And she was thinking of her son this entire time. Maybe that's why she didn't jump out of a moving vehicle. She was thinking about going home to her son. And she was scared that the defendant would use the knife and carry out his threats. That's what was going through Dubiella's head as the defendant beat her, took her, raped her vaginally and anally.
Excuse me, just a moment. All right, ladies and gentlemen. This case is to be decided on the evidence that you've received. Does everyone understand? Any objection with the court giving that order, defense? All right, you may continue.
She didn't want to be raped vaginally and anally. She tried to escape, yes, by yelling out of a window for help. She knew she couldn't jump from a second-story window. And she is here today by herself to end his terror. And I want to talk to you about what defense said, what makes sense. In jury selection, we talked about this. What makes sense for a witness, for you to judge their credibility? We look at their demeanor. We look at if they have any motives to lie. We look at, does what they say make sense? Is there corroboration of what they say, either through evidence or other witness testimony? So let's talk a little bit about that. Her demeanor up on the stand, she was questioned for 2 days, for about 6 hours, by myself and by defense. And what did he focus on? He didn't mention it in closing statements here, but if you'll remember from his cross-examination, he focused for quite a bit on how many rings hit her in the face. Remember that? And she told you, I don't remember how many rings hit me. I can tell you, I still have the scars from them on my face. He focused on what kind of beer did he drink? Was it in a can or was it in a glass bottle? I imagine why he didn't mention that in closing statements today is because we showed you exactly what kind of beer in a glass bottle and what kind of gold rings were on the defendant when he assaulted her. And so now he wanted to focus on a lock that the barbershop owner did testify was janky. But we don't have to prove to you that he locked her in the barbershop with the key. We have to prove that he held her there because he beat her and he had scissors in his hand. I also want to talk to you about motive to lie. You didn't hear any of that from the complainant or from the defense through his cross-examination. She has no motive to lie to come here a year later and talk about how she was brutally assaulted and raped, something she didn't even want to go to the hospital for because she was so embarrassed, even though she was bleeding afterwards, even though she was bleeding from her anus and her face and had scars. That's how embarrassed she was of what she let him do to her. I also want to talk about the corroborating evidence. You heard from the complainant that the defendant came into the barbershop, hit her in the face several times. She fell to the ground. He went outside, came back in with scissors. While he was outside, she called 911. We brought you the 911 custodian of records, and she told you that there was a call on May 4th from this shopping center that was a call hang up because the defendant came in and took that phone from her. They tried to call back and they weren't able to get a hold of her. That's corroboration of her testimony. We brought you the officers that responded on that date. They went to the wrong location. They went to this Indian restaurant. And ladies and gentlemen, they were here in this parking lot for less than 5 minutes. That's what Officer Mata talked about. That means they arrived at this parking lot, stopped their vehicle, unbuckled their seatbelt, got out of their car, looked around for a minute, walked into an Indian restaurant to talk to that restaurant owner, came back out, looked around for a sec, got back in their cars, and then ended the call. All of that within 5 minutes. How hard did they really look? And Officer Mata testified he didn't even go up to any of the other shops. He was in the parking lot away from everything. I hate to be as cliche as this, but pictures really are worth 1,000 words. Duviela testified to a brutal assault. And that's what's shown in these pictures. And I know yesterday or Friday over the overhead, you might not have been able to see them as clearly, but I want you to really take a look at them back there. Because she has bruises all on her face, on her abdomen, on her legs, on her thighs, on her back, on her side. Because that man brutally beat, kicked, punched with gold rings, causing these injuries on her face. That evidence corroborates her testimony. And you can use her testimony as evidence to satisfy the elements that we have to prove. That means that if you believe what she said up there on the stand beyond a reasonable doubt, and you believe she's testified to every element the state has to prove, then you can find him guilty. And we have. Everyone testified that this occurred on May 4th of 2024. Everyone testified that it was in Bexar County. The defendant's address, Horizon Hill, was in Bexar County, and the barbershop is in Bexar County. And the complainant stood on that stand and pointed out the defendant as Angel Miguel Cespedes Rhonda, and that he was the person who did this to her. Those elements aren't in question. What we have to prove in paragraph A is that with the intent to inflict bodily injury, he kept her in that barbershop where she was not likely to be found. How do we know she wasn't likely to be found? Police were looking for her and they didn't find her. Paragraph B, with the intent to violate or abuse her sexually by keeping her or by taking her from the barbershop to his apartment. That is what she testified to. He took her at knife point from the barbershop to her apartment, where he brutally raped her vaginally and anally. Paragraph C, we have to show that he held her in a place where she wasn't likely to be found, the barbershop, where police couldn't find her, with scissors, which she testified to. Paragraph D, we have to show that he took her from the barbershop to his apartment with a knife, which she testified to. Now, scissors are a deadly weapon. She testified that, Officer Ruiz testified that scissors could very well cause death or serious bodily injury. Duviela and Officer Ruiz testified that a knife definitely could cause death or serious bodily injury, especially with it up against her throat. I want to talk a little bit about the deadly weapon element. As Rick said, you do have to actually check that on that page. It's going to be the last page of the jury charge. And I do just want to say these paragraphs are like Rick said with the bullet points. They are or, okay? 6 of you could believe paragraph A was proven beyond a reasonable doubt. 6 of you could believe paragraph D was proven beyond a reasonable doubt. As long as all 12 of you agree that at least one paragraph was proved beyond a reasonable doubt, then we have met our burden, and he is guilty of aggravated kidnapping. I want to point out that Duviela did everything right. She tried to leave an abusive relationship multiple times. He wouldn't let her. This last time, he beats her and rapes her and takes her. He wouldn't let her leave. That was because she broke up with him, and he didn't want that to happen. She was his woman, remember? She called police after he assaulted her in the parking lot. She had to wait on the line for an interpreter while he's out in his car coming back inside. She doesn't know how long she has, and she's waiting for an interpreter so that she can actually ask for help. She finally does. He comes back in, takes the phone from her, and that 911 call is ended. Officers respond. They go to the wrong location, and she's being held in a barbershop at knife point, and they're next door in the parking lot, spending less than 5 minutes on this call. 5 minutes. She tried to escape from the window. She tried to yell for help. She tried to leave in his apartment. He wouldn't let her. The next day, she tried to tell cops what was going on. Again, there was a language barrier. They had to have officers who spoke Spanish come out and speak for her. And Officer Ruiz testified on this stand how convoluted that was. He was asking her questions through Officer Marchand. Officer Marchand was asking her questions. She was answering Officer Marchand. Then the CSI was also asking her questions, telling her to move this way and move that way to take pictures. It was a cluster of everyone asking questions, and she didn't understand what was going on. She finally had the opportunity to write down what happened to her in that 2089 statement that we talked about. She talked about the knife. She talked about the scissors. She talked about the rape. In that statement, she wrote everything down because she finally could in her own words. And they didn't look at it. She was told that she could wait for a female CSI. Officer Rodriguez got up on the stand and told you there was one female CSI officer in all of San Antonio. Sure, she could wait around for that with her 6-year-old son in a parking lot. Or she could just take the pictures herself, which is what she decided to do. And that is why we showed you, defense wanted to bring up the injuries on the day of and how these could be, I don't really know, but that's why we showed you there were injuries on the day of. These were the same injuries that are shown in her face. As Officer Rodriguez testified, they get worse over time. It wasn't until Detective Lopez finally gets the case. She looks at the 2089. She sees everything that happened to this complainant, to Duviela. And I'll admit, she did not do what defense said. She did not do a rape kit. She didn't do DNA. She didn't do a search warrant. She is a misdemeanor CRT detective, but you know what she did do? She listened to Duviela. She met with Duviela. She got evidence from Duviela. She did her job because she brought us this case to be put in front of you. You know who did hear Duviela's pleas and didn't listen and did have malicious intent? This defendant. He heard her pleas to stop. He heard her pleas to let her go. He heard her pleas to end this terror, and he ignored them. But Duviela didn't let him. She ends his terror here today. She came up this week and told you everything he did. She wants to break this cycle of violence, and she wants to take back control of her life, and we are asking you to help her. We are asking you to protect her, to protect this community from this man who thinks that these actions are okay. We are asking you to send him a message that his actions will not stand in this community, that women are not property for him to keep. And we ask that you find him guilty.
All right, Deputy Laura, you may take the jury back.
Rise for the jury.
Where are we at?
Send that in.
You got anything for that?
Are you? Good.
Your babies.
Good. It's growing. It's small,
Oh,
smaller, they're. I do anything that's. Definitely.
same person.
You know, we started at, well, today. Starting from 5, 1, and 6, 6, 6.
So I'll do. That's what's possible.
Yes,
I'm gonna go run to another court, try to catch up on some.
sure, no problem.
I left my number if they appeal.
All right, thank you. Have a good one.
But the best ones, there's,
Oh, really? They've been fast.
yeah, it's okay.
I know, together. It doesn't hurt, like, 2, 3.
Yes.
So what's inside?
Someone's on our trial docket for today. Mr. Otero is here. I believe he's talking with her.
All right, thank you.
Thank you, Judge.
Thank
Thank
you.
you, Judge.
You're welcome.
Okay.
That's Jack. Okay. We know that. Sure. Oh, it had been. Somebody good.
Yeah, I didn't go very much, but I shared that there were. Okay. Thank you.
Yeah. Yeah.
Nobody has a return to anything.
To the side. On the wall says, it's, it's 15, it says.
On what?
Following up on a comment you just made, and can we possibly go offline for just a second?
Now I know.
It's different, but the
What does it say?
underlying emotions are the same.
Tavares Warren. All right, thank you. So I'm gonna have Deputy Laura, when we get a chance, call him in the hallway. And if you want to call him to see if you can find him.
Okay,
Thank you.
thank you, Judge.
Joshua James Casey. Kevin Trejo.
President, Your Honor, we should have a plea for you shortly.
Thank you. Yes. Is this on the docket for today? All right, so I need the file. I don't have the file. Here you are. All right. Mhm. All right, so on Samuel Bach.
Good morning, Your Honor.
Good morning.
Okay, so this is an ex parte motion for funds.
All right, so let me just, I'll read that and I'll read the lack of finances attached to it.
And so, we did file a stamp copy. That's just my hard copy here. So exhibit C on the forensic toxicologist should be the exhibit A. It's the exact same affidavit.
Okay.
It has been accepted via e-file, but
You know, when you do the ex parte and you e-file it, do they have it where it's e-filed ex
Deal.
parte?
I don't know. I'm not really trying to hide it.
Okay.
I'm just saying they don't have to come up here
Okay.
for the motion, but
Okay,
I mean, we've already disclosed that they're experts in this case.
all right. All right, I'll review it. There shouldn't be any problem with it. And then we'll, depending on what this jury, where this jury's at, we'll either start jury selection today or tomorrow morning.
Okay.
All right.
thank you. So just hang tight.
Yes,
Do you want me to give my cell phone number?
sure. I will tell you what, just come back at 1:30.
1:30? Okay, perfect.
All right, thank you. Thank you. Oh, just 1:30.
Oh, well, I'm gonna give it to her anyway, just
Okay.
in case you need anything.
Yeah.
Special setting.
Sure.
I'll have it for.
Okay.
Are you good?
Yes, we're good.
Okay.
Oh,
Are you available for an introduction?
yes, I am.
Jonathan, Judge Boyd.
Hey, Judge.
Hi.
Jonathan, my brother.
Hi. Nice to meet you.
I was a prosecutor up until Friday, now I'm defense attorney. So how you doing?
Hi, welcome. So how's it going?
So far, so good. I'm on the wheel for first degrees down. So I'm starting to get appointments, but nothing's, currently set.
Oh, wow. Well, welcome.
Thanks.
I will tell you, I remember was there a will when we first started, John?
Yes.
All right, there was a will, but there,
Classmates in law school.
yes, there was a will, but also early bird gets the worm, right?
Yes, for sure.
And so I used to take the bus. I had my little backpack. And the only bus that would get me here on time would be the bus that would get me here at about 7:30 a.m. So I was downtown every day at 7:30 a.m. And I would always pray, please let me catch the 90 because 90 was the express. It doesn't have any stops and it takes you on the freeway.
Yeah.
The 92, oh my gosh, the 92 takes, but you learn the city.
Yeah.
That's how I learned. You can get on Fredericksburg. If you're ever lost, just find Fredericksburg and it takes you everywhere. But the 92, oh, you can go to sleep on that bus because there are so many stops. And in my mind, I knew the number of stops before I got to the medical center area. So I was just, but I will tell you this, starting out, everybody always thinks attorneys are billionaires, right? Like multimillionaires, like there's this big firm.
Right.
For me, like Perry Mason, where you have a secretary who has a secretary and you know, the investigator who has other investigators who work for them. But the bus was great because on the bus, I ended up picking up so many clients. I don't know how they knew I was an attorney. I think maybe because I was being dropped off at the courthouse every day. Either that, I was accused of murder and I had to be in court every day. So finally, this guy who rides on the bus, he was like, Stephanie, I'm Doc. I'm like, hey, Doc. He said, so why are you at the courthouse every day? I'm like, oh, I'm a new attorney. Then Doc started advertising for everybody on the bus. This is Stephanie Boyd. She's an attorney.
Oh, there you go.
And I picked up so many clients on the bus because believe it or not, on the bus, you have a lot of people who are charged with DWIs. Right. If you need clientele, ride the bus.
Yeah.
You can't solicit,
Advertising.
but if you sit there, people will start saying, why is he coming downtown all the time? But welcome. I will tell you, you will discover that the criminal defense bar, they're very nice attorneys. So
Oh, they are.
yeah,
Sounds very nice.
yeah. So whenever you, if you need anything or you have a question about something, they're usually the people to ask. And this is what I always told my students when they were first starting out. And I said, do you want to know who you should go to negotiate and get an offer from? They're like, who? How do we decide when we don't know? I said, see who has the longest line.
Yeah.
That's usually it.
Yeah.
And then when the person who doesn't have the longest line said, may I help you? You know how you respond? Oh, no, I'm just reviewing things, but I'll come to you. And then you go to the other person.
Right.
But everybody in here is.
Or you do a Fred Sanford fake attack. Elizabeth.
Elizabeth. But well, welcome to the defense bar.
Judge.
If you need anything, just let us know.
I will. Nice to meet you.
Oh, you too. All right, everyone, we're breaking at noon. And the jury, you know, if they are back with their verdict at 1:30, we're going to start up and you're going to have to be called for another day, which will be tomorrow for our jury trial. Post report, sure.
I'm just thinking outside the box. I have a client, this is a very first setting.
Is it a circle? You're outside the box.
First setting, I'm having trouble with discovery because it's so voluminous. And Jason just gave me a
You need
great
to have
offer.
them pull the file.
Okay. On, congratulations. Brian Warley. Brian Warley. Yes, bro. I think they brought him up. And Jason wrote me an offer that I think I can't refuse, but I know how busy the court was.
All right, they're not ready on that just yet.
Yes. Very good.
Thank you.
I heard.
Oh, hi, Jason. I didn't see you standing there.
No problem.
All right.
I was taking a break.
Okay, you know what? You can take a break from the madness. We'll pretend there's something legal going
Every
on.
once in a while, right?
This is, I'll just stare at this for a while.
It's on today's docket though.
Okay, all right, thank you.
She's cooperative, she's one of the food
All right, George Abaye.
Go ahead.
Morning. Court is calling 2023 CR 3141. Just 1 second, I'll wait. State versus George Abaye. Can I have parties announced?
Rick Payne for the state of Texas.
Kevin Tjo, Mr. Bye.
And are you Mr. Abaye?
Yes, ma'am.
All right, there's a request that a bond be set.
Yes, John.
Right, so I see on the docket that he had been remanded without bond for not appearing on the June 17th.
That's correct.
All right, and you all have agreed to a bond of 10,000?
Yes, correct, John.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Yes, ma'am.
State your name for the record.
John Abaye.
All right. So, Mr. Abaye, have you ever been previously deemed to be incompetent?
Mm.
All right, ever received any type of medication for mental health issues?
No, ma'am.
Ever seen a psychiatrist or doctor for mental health issues?
No.
Okay. Have you ever used any type of controlled substances or drugs in the past?
No.
All right. So you were set on June 17th, 2024 in this court. Is there a reason you did not appear?
Yes. On the day before, I lost my my mom. And then before I could get over it, the next day I lost my dad between 2 days in cover.
Mhm.
So since I'm the only boy, I had to do some runarounds with my uncle. And that's why it's called.
All right, do you have documentation of this?
I do not, I do not with me, Judge, but if the court would like, I'm sure we could work on getting something.
All right, well, have you verified that he's lost both of his parents during this time?
I have not, Judge, I have not, we just discussed this morning.
All right, does somebody want to Google?
They are not in the States, Judge, is my understanding.
Yes, ma'am. They were in England, London.
Does somebody want to Google for the United Kingdom, deaths in the United Kingdom?
Defense wants to do it, any more time to gather that, they would have no objection. And then
All right, because this will, of course, help me make a decision on what the bond amount should be to ensure his appearance.
Okay, Judge.
All right. And I think you all may be able to discover that today. I'm sure England has something similar, maybe not to the United States, where you can Google and find out.
Okay, Judge.
All right, thank you.
I don't think you're- Simple? That is simple?
I get it.
I'll talk to you.
Charles Brunel?
Yeah, I'm Charles Burnell.
Sure. Mike. This is-
Yes. Okay. Because I can do
Let's see, Galvan. Galvan and Rodriguez.
All right, everyone, give me 5 minutes, then I'll come back and I'll take up Trejo for plea and El Gadrab. All right, Kevin Tjo. Come forward. Court starts at 9. You need to be on time. You understand?
Your Honor, he wasn't on before by accident.
All right. Have you been to the court before?
Oh, this one?
Yes.
I had tried coming once, but I didn't see the date and
Okay. All right, so you need to make sure you know where you need to be, all right? And this is very important because is this an application?
Your Honor.
All right, so you're gonna have to make sure you make your appointments on time for probation, you understand? All right, the court is calling 2025 CR 008-042. State versus Kevin Luis Trejo. Could I have parties announced?
Jason Garahan for the state, Your Honor.
That was got my trail.
And are you Mr. Trejo?
yes.
And am I pronouncing your last name correctly?
You
Okay. Counsel, have you received all discovery? Did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Trejo, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, I did.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, I did.
Counsel, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it?
Yes, I did.
And did you sign it in all the appropriate places?
Yes, I did.
Did you understand your charge of possession of a controlled substance penalty group 2 less than 1 gram?
Yes.
That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses? Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Trejo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did.
According to the plea, there's a $1,500 fine. State is recommending deferred adjudication. There's to be restitution to SAPD for drug testing. Did you understand that to be the plea? Defense?
Yes, Your Honor. The state has agreed that I couldn't ask the court to reduce some of the fines to what was previously found to be in.
All right. And state, is that the plea?
Yes, it is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation, 120 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. State exhibit number 1 with all its attachments.
No objection.
All right, state, you may be excused. Did you review the waiving stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, if you have the defense attorney come back.
Yes.
We're back on the record. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Your Honor,
Anything you wish to say on behalf of your client?
just my client has been working to change his life, Your Honor, and looks forward to completing probation.
All right, so if you're drug tested today, what are the results going to be?
I will tell.
For marijuana, Your Honor.
No one but,
Well, I mean, let me
Sorry, we
talk to,
discussed
that's
it.
okay. So what are you going to be positive for?
marijuana.
How often are you using?
I would smoke like every other day. I would smoke.
All right, so when's the last time you used?
2 days ago.
All right, so here's the thing, when you're on probation, you're not allowed to use marijuana, you understand?
Yes, I understand.
Do you have any children?
No, I don't.
All right, and do you live by yourself?
Yes,
All right. So it's just you,
yes.
no one else?
No, man.
All right. Are you employed?
Yes, I'm employed full time.
What do you do?
I do metal roofing and construction.
Well, that's hot to be doing that.
I've been a summer here.
All right, so the metal roofing, do you ever accidentally cut yourself on the roofing?
All the time.
Oh my gosh, I can't even imagine. And so I'm assuming you have gloves because the
do.
metal gets hot, right?
Yeah, it's pretty hot. This is the hottest time of the year right now.
Oh my gosh. All right. This is what the court is going to do. There's a $1,500 fine that will be probated. 2 years deferred adjudication. Proof of employment within 30 days. No employment as a home health care provider or with minors. No residing with minors. Field visits 1 time per month for 5 months. 120 hours of community service restitution. That will be deemed satisfied if you obtain some type of trade certification or higher level of education. How far did you go in school?
I graduated high school.
All right. There's to be regular reporting by Zoom or in person. Regular random UAs. Test for levels, please. There's to be no driving until insurance, liability, and valid driver's license is produced for probation. All right, and the reason why I'm doing that, but it's because in the police report, it said that they pulled you over, your registration was off, and then insurance issues. So,
That wasn't my personal vehicle. That was the boss's truck. And I don't even have a vehicle at the moment, you know.
all right, just make sure. So that's the only way you'll be able to drive. You'll need a valid driver's license and insurance, and you'll need to show that to probation. You understand?
Yes, and I think I'm not allowed to get it with the DPS, with the license. I think I have to wait for a whole year, please.
Oh, whatever license. But yeah, but you cannot drive without a driver's license. You understand?
Thank you.
Okay.
He was around when I was putting on my belt.
All right. Is there anything else that you need from the court?
You help me.
Probation, is there anything else? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, You do not have the court's permission to appeal. Do you understand?
I understand.
All right, we can go off the record. In this court, to be successful on probation, yes.
I'm sorry, you're on the record, but I was asking the court at such time during this 2 years, if you get to find a girlfriend or boyfriend with children, they could modify that provision if he had to
Yes,
approach the court regarding that matter.
yes.
Thank you.
You're welcome. So, in this court, in order to be successful, communication is key. If you have an issue, let probation know about it. If you feel as though they're not addressing it, you can always come back to court. And with regards to your use of marijuana, those levels should start going down. You understand?
Yes, I understand.
All right, good luck to you. Remain in the courtroom and probation will speak with you.
All right.
Thank
Thank you,
you.
Judge.
Thank you. Who just does not want to turn off their phone? Oh, it's the jurors? Oh, I know they're probably saying like, I need my phone. All right, could I have the printout from that, please? This printout? Yes. It does, right? All right, sure. Oh, we'll need an interpreter, so y'all can read it.
I knew, actually, he's not even here. He's here.
Okay, sure. Vincent Arredondo. Hi, where's your client?
We're requesting if we can be recalled till tomorrow. We're close to getting it worked out. Duffy just needs a little bit of time to look at some things. They've made an offer, we've made a counter offer, and he said maybe he
Okay.
just needs a little bit of time, but maybe come back when I'm sorry.
Oh, no problem. It's a crowd over there, I know. All right, Deputy Norma, Mr. Arredondo is going to be brought back tomorrow dressed for trial. All right, thank you. Oh, and Nice outfit that you have for him, Megan. No.
Let's go, be there.
Oh, okay, well, good job.
Thank you.
You're welcome. I'll see you in the morning.
Are you gonna be able to let that right tomorrow?
Oh. Thank you. All right, Pedro Rodriguez.
Test judge.
Rhonda? Okay, I see you. All right, thank you.
Hi, Judge.
Hello.
So I conferred in the past with the DA, they made us an offer. I conferred with my client, we're not interested in the offer, Judge, so we need a trial.
All right, I need a jury trial date. It's family violence.
That's fine.
All right, October 7th will be your jury trial date. I need an acknowledgement of discovery. All right, Deputy Laura, Mr. Rodriguez is coming back for jury trial. Mr. Rodriguez? Mr. Rodriguez? Pedro Rodriguez? Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you'll have to plead open to the court. Do you understand? All right, thank you.
Thank you, Judge.
Welcome.
Judge, I've got one other case. This Christian is assisting me with that.
Okay,
I've got a plea in the 227, so I'll be back and forth.
all right, thank you.
Thank you.
And so state on that one, if you prepare the acknowledgement of discovery. All right, Mr. Reitmeyer, is your client here? All right. We're gonna go on the record. Court is calling 2025. Oh. All right, the court is calling 2025 CR 0028807 State versus Angel Cespedes Rhonda. Could I have parties announced?
Sir Kenyon Essex Jones for the state of Texas.
John Reitmeyer for the defense.
And your client is present, correct?
Yes, ma'am.
All right, we do have an interpreter. The interpreter has been previously sworn. The court has received the following question from the jurors. Can we request the police reports? Have both parties had a chance to review the questions?
Yes.
The court proposes the following supplemental charge. With reference to your inquiry, you now have before you all the testimony, exhibits, and evidence that was admitted, and you are instructed to continue your deliberations. Any objections to that answer, state?
Not from the state.
Defense?
No.
Any objection to the court sending the question and answer back to the jurors through the deputy?
Not from the state.
No.
Thank you.
Thank you.
Okay. All right, if I could have the person here for the warrant, please. Who's on Taboris Warren? Taboris Tremaine Warren Jr.
That's Teresa's.
Sorry.
Oh, no problem. Jamar Clark. Good morning. Hello, Mr. Clark.
Hello.
Thank you for dressing appropriately for court. You always do, though. Let me see. All right, so you're scheduled for jury trial. So I'm going to have you come back tomorrow at 9 a.m. And jury selection will probably begin probably about 10 because it takes a while to qualify jurors. So once you sign the reset form, you excuse. And if everyone can make sure that I have an acknowledgement of discovery.
Here's the kind of an issue that we have here, just
Okay.
briefly. This is our first trial setting, maybe our second.
No, it's not the first.
Okay, I think it's our second. Anyway, just recently, there's some new evidence that came up that the state wants to review and I want to review. And I was gonna see if we could get like a 10-day reset or a 7-day.
Well, I mean,
reset.
I'll hear it tomorrow.
Well, we don't know if we can have it by tomorrow. That's the issue.
Let's see.
Okay.
All right.
This is also new evidence that the state didn't know of. So
Okay.
it's not like we found something we wanted to tender over. We want a way to corroborate it, and it could push this case a certain way.
Okay.
And so if we did have that 10 days, if we didn't have it tomorrow, we'd show up and we just found out about it today.
Okay. I mean, it could happen. Anything is possible. So we'll see where we are tomorrow, and then that way, if there is some issue, and what I can tell you, Mr. Clark, if it's something that neither party knew about, and it's something that both parties are just learning about, I take that into consideration. It's different than if there's been evidence that's out there that both parties knew about it and they're just asleep on it. But we're going to see where we are and see what the evidence is. And then I can make a decision if you do need a reset, the length of time, because it may end up being more than 10 days. I don't know.
Okay.
Okay.
Thanks, Joe. All right. Thank you. Sounds good.
You're welcome. All right. Just once you sign the reset form, you're excused.
Thanks, Your Honor.
You're welcome.
Over one, they get you on this. Yeah, okay.
Juan Rivas.
Present, Your Honor. Hello, Judge.
Hello. Where are we, Mr. DeLeon?
With Mr. Rivas, we have absolutely no discovery. So what I've done is talk to prosecutors, give them a flash drive. We're gonna get everything put onto a
Why
flash drive.
why is there no discovery? This has been on the docket since June.
Yeah, it's there, but he can't access it.
We put in the number that is associated and it comes up blank. And we've tried a couple of times, so here we are with a flash drive now. Do it the old fashioned way.
So this is an Odyssey problem.
It is absolutely an Odyssey problem, and Joe Gonzalez is the one who bought Odyssey, so you'd have to blame him.
I think it's the commissioner's court.
All right. Look at people just throwing everybody under the bus. You know what? It reminds me of that. My brother told me about this guy, and they do it as a cartoon character where he's like, I will not testify against anybody. I'm 10 toes down. And then they're like, life in prison. And then he stands up and he said, it was him, and starts pointing out everybody. But you all are not even facing that. And you're just throwing everybody under the bus.
But additionally, Judge, we did have a motion to change Mr. Rivas's GPS. It's full right now. We're trying to change it to partial so it can work. That's the big thing.
And wasn't this the one that I discussed before? Was that a different one?
No, probably a different one.
Those are
All right.
different.
So do you have an issue with his being allowed to work?
Do you have an issue with that motion?
Sorry, the vet hadn't had a second to look at it.
He wants to be allowed to work.
If I remember right.
Proof of employment, Your Honor, we would just need to see that and talk with the complainant's family to see if they have any objections. In speaking with them in the past, they are concerned about their safety.
All right, so here's what I can tell you all. You will need to provide proof of employment and your schedule, your hours of work. And then they will give you a location that you're not allowed to be at, which I'm assuming is the complainant's home. And what is your occupation?
I'm a truck driver.
You're a truck driver. All right, so if you go to a truck stop to put gas in your vehicle and you happen to see the complainant there, just stay in the vehicle, because I know when you're driving trucks, sometimes you can't make it to the next stop because diesels use a lot. Just stay in your truck. Don't look at anyone. You understand?
Yes.
So I'm going to allow him to have employment. People have to work, but you all need to craft the order so that he knows a location that he is not to be in. And I'm assuming, rightly or wrongly, that he knows where the complainant resides.
Yes, Judge.
All right.
Well, he doesn't know, but.
He has a general idea.
Abide by a no contact order. That shouldn't be a problem whatsoever.
All right, so if you all will fill out the order and then, Ms. Ferguson, I need a 45-day reset on this for discovery. And if there's some CPS records, you all need to make sure you have those.
We do, Your Honor. Defense is presenting you a protective order for those CPS records so we could release them.
All right, thank you.
You can do it, Judge.
All right, that will be your discovery date. And once you bring the court the order, the court will sign it.
We're gonna work on that, Judge.
Your counsel.
Thank you.
And counsel, off the record for a moment. All right, thank you. Just have a seat. Thank you for dressing appropriately for court.
Just have a seat. I'll be right with you.
Just, no, I'm going, just give me a moment.
And then just a bit.
Okay.
Hold on.
Yeah. Judge can take one more for you.
Okay, sure. Who is here on Adam Herrera? Good morning, how are you doing? All right, the court is calling 2024 CR 01273 State versus Adam Herrera. Can I have parties announced?
Jason Garrett here for the state. William Davidson for Mr. Herrera.
And are you Mr. Herrera?
Yes, ma'am.
All right. Is there an application in this?
No, you are.
Right. Mr. Herrera, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we'll waive the enhancement.
Any objection?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Herrera, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand your charge of possession of a controlled substance penalty group 1 to 4 grams as a 3rd-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Herrera, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 2 years in the prison, and there are no applications. Did you understand that to be the plea?
Yes.
Defense?
Yes, ma'am.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Given every one with all of its attachments. No, Judge.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, he may benefit from the therapeutic community, which I told him about.
All right, the court will follow your agreement. The court will sentence you to 2 years in the prison, give you credit for any time served. I'll request the therapeutic community for you. There's to be no contact with Extend A Suites at 9735 IH 10 35 North 172, San Antonio, Texas 78233. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing, the therapeutic community doesn't increase the time that you're in custody. I can't order you to have it, but they'll show that I'm requesting it for you in the judgment. You're gonna have to ask for it. How old are you?
26.
All right, so you're gonna have to start making a decision, because this is not a good path to be on. When you're released from custody, if you can't find a sober support living house, or if you need help with maintaining your sobriety, if I'm still here, you can come back here. I will pick up the phone and call somebody to help you. Otherwise, only 1 or 2 things gonna end up happening to you. Either you're gonna end up in and out of somebody's jail or in and out of somebody's prison, or either somebody's gonna end up identifying your body, because the last time you use may be the last time you use. You understand?
Yeah.
All right, good luck to you, okay?
Yeah.
You're welcome.
Thank you, Your Honor.
Sure. Mahmoud El Gadrab. Good morning. All right, so you all are scheduled for jury trial. So see you all to, yes.
I believe this was discovered. That's right.
Oh, somebody said jury trial on the docket sheet.
Was it?
False statement in property credit, is that the charge?
Yes.
Let me see.
Sorry, mine said discovery.
Mine, I go get my reset numbers, but this for discovery.
All right, let me just check. All right, this writing is not my handwriting, but I do have in the judge's notes, final discovery, defense. You tendered some information to the state. And actually, this is supposed to be on the docket for August 15th instead of today.
I don't know, I just come when I'm told.
All right.
And we do that. I think
Yeah.
all of us.
Yeah, it's supposed to be August 15th. I don't know why it's on the docket today.
So I'm still trying to get that information, Your Honor. Do you want us to come back August 15th?
That's what it states on here. That's your actual reset date. And it was for you to tender information that you had to the state, but let me move it around. I'll put it on August 19th. Yeah, because we were in trial, and so it was supposed to be back here on August 15th. So I'll put it on August 19th.
Thank you, Judge.
You're welcome.
Okay, thank you, Your Honor.
Thank you. I also have a motion to set reasonable bond, but obviously he's on bond.
The court's already moved up.
Okay,
We have first signature.
sure.
Sorry.
Thank you. Here you are. Tavares Tremaine Warren Jr. Michael Sanchez. All right, thank you. Hello. All right, so where are we on discovery?
Judge, I need a little more time to peruse the discovery, and I need to find out some more things about this.
All right, I need a 30-day reset for discovery. And this is Michael Sanchez.
Yeah.
All right, your discovery is September 9th. All right, thank you. Do you have any questions?
No.
All right, they'll bring you back on September 9th for discovery. You're welcome. Brian Warley. Who's the attorney?
You stepped up.
All right, thank you.
Yeah.
And is there a plea on both cases? Let me see. I think it is.
Yeah, and we're waiving count one, she now counts.
Okay. All right, the court is calling 2025 CR 002461 and 2025 CR 007846, State versus Brian Warley. Oh, I'm so sorry. No, this is a different case.
Yeah, Judge.
So, if you guys could step back for me just a moment, there's one that's ahead of you.
Thank you.
Well, no, somebody put a sticky note on this one that said Brian Warley. All right, who's here on Logan Denny? All right, that's okay. Court is calling 2025 CR 002461 State versus Logan Denny. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Kimberly Bush for the defendant.
And are you Mr. Denny?
Yes, ma'am.
One preliminary matter I'd like to raise before the plea, if I may, Your Honor.
Sure, you may proceed.
Okay, I have been retained after this case began by Mr. Denny and his family. The prior counsel had, or somehow it had been ordered that there was a competency evaluation which was to be done. That took some time to get done, but it has been done. The report found him to be competent. I fully concur with that in my professional opinion as a lawyer and my personal opinion as a person. I have the report to tender to the court if the court would like to see it. I have discussed this matter with the magistrate court and they suggested I bring the report to you and that
Yes.
we waive the competency and proceed. Or that you declare I'm
Yes.
competent, whatever the proper procedure would be.
All right. So with regards to the matter of competency, State, have you had a chance to review the document from Dr. Eric Cardwell?
The state has not personally, but in discussions with defense, we've been made aware of the results. And we believe that there are people within within the district attorney's office who are aware and we are allowed to proceed.
All right,
I did discuss it with Sally Unkefer yesterday.
all right. And so both parties agree that Mr. Denny is competent to stand trial?
Yes, Your Honor.
Yes, Your Honor.
All right, Mr. Denny, you're aware that you do have a right to have a jury, if you request a jury, make a decision on whether or not you are competent or incompetent?
Yes, ma'am.
All right. Are you waiving the right to a jury to determine whether or not you're competent or incompetent?
Yes.
All right, after reviewing the report that's been tendered to the court as, if you could mark that as an exhibit, please. As
I'll mark
defense
it as
exhibit
defense
number one,
exhibit number
and
one.
there's no objection to defense exhibit number one?
None from the state, Your Honor.
I'd request it be admitted.
All right, defense exhibit number one is admitted into evidence. If you'll just give it to the court reporter. All right, any arguments from either side with regards to competency before the court makes its ruling on competency?
None from the state, Your Honor.
None from defense, Your Honor.
All right, based upon the evidence that's been submitted to the court in defense exhibit number one, and also based upon evidence that has been submitted other than defense exhibit number one, the court will find that the defendant is competent.
Thank you, Your Honor.
Counsel, oh, you're welcome. Counsel, have you received all discovery in this case and that you review it with your client?
I have received the discovery and I've reviewed it with my client, yes.
Court will find that the state is in compliance with discovery. Mr. Logan, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, we are.
Mr. Denny, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor, I did.
Did you understand you're charged with the offense of theft for property, $2,500 to $30,000? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this cause?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Logan, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 300 days in the Bexar County Jail under 1244. There's to be no contact with Best Buy. Did you understand that to do the plea?
Yes, Your Honor.
Defense,
That is our understanding.
state, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes,
Counsel, have there been any such motions?
There have not, Your Honor.
Into the offenses charged, how do you plead? Guilty, not guilty, or no contest?
no contest, Your Honor.
State any evidence?
State offers State's Exhibit 1 and all attachments are in.
No objections.
All right, state, you may be excused.
Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
My client has been in jail since January 9th for this offense. It has given him the opportunity to reflect, perhaps involuntarily at first, but later on, at least partially voluntarily. I believe that he is more than ready to move his life forward. Also, my understanding that given the number of days, this is, I believe, to be a judgment satisfied. And I would just ask the court to accept the plea and let my client move forward with his life. He's a new father and he's looking forward to new beginnings.
Oh my gosh.
Yeah,
Your new father?
Yes, Your Honor.
and he has not met his child yet except on video, in the video visit.
All right, so these things happen when we commit
Yes, they
crimes.
do.
So you're gonna have to change your life because you have a new child. You understand? So here's what I'm gonna tell you, and this is what I would always tell people when I do CPS cases, when I would represent parents. If you have no intention of being in your child's life and being a good influence, just walk away. They're better off without you. You understand? So don't bring marijuana in their household. If you have issues with competency and you're on medication, you need to stay on those medications because you're supposed to put your best foot forward for your child. You understand? All right. The court is finding you guilty. The court will sentence you to 300 days in the Bexar County Jail under 1244. There's to be no contact with Best Buy, no contact with Matthew Dillon Yarborough or Ibarbo, Yborbo. With regards to whether you have a judgment satisfied or not, they will calculate the time. I've told them to give you credit for any time that you've been there. If you're at the jail and you think you should be getting 2 for 1 or 3 for 1, that's what the jail does. I have no control over that. What I can tell you is I've sentenced you to 300 days. So you will do no less and no more than 300 days. You understand? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, read and go off the record. You made your life very difficult because what you're charged with and what I found you guilty of is a crime of moral turpitude. So what that means is anything that is going to require you to have a license, this is going to pop up on your record. Now, does it make it impossible for you to follow your dreams? No. It's just going to make it very difficult. You understand?
Yes.
All right, good luck to you. You're welcome.
Thank you, Your Honor. May we be excused?
Yes. All right, Brian Warley. Has their order arrived yet? Yeah, you know, I get accused of being hangry. I don't get hangry. Right, Rashawn?
Right, Judge.
Thank you, Duffy. Duffy, I appreciate you. Rashawn was a little bit low on the response. But I saw what you were saying with your eyes. Jason, I don't get hangry, do I?
Never.
Thank you. Megan, do I ever get hangry? Thank you. Rick, do I get hangry? Ashley, do I get hangry?
Of course not, Judge.
Thank you. I don't know what the other people are talking about. All right, the court is calling 2025 CR 007846 State versus Brian J. Warley. Could I have parties announced?
Jason Garrett, Hampton State, Your Honor. And Eric DeWalt, I represent Mr. Warley.
And are you Mr. Warley?
Yes, ma'am.
And counsel, is your daughter here today?
He is, Your Honor.
Come up, please.
Yes, ma'am.
We're all mentors and she's shadowing you, which is great. And I'm so sorry, what's your name?
For the record, this is Josephine Blair Marchetta DeWalt.
Hi. All right, welcome. All right, so counsel, you received all discovery and reviewed it with your client?
Yes, Your Honor, to my satisfaction, yes.
All right, the court will find that the state is in compliance with discovery. Mr. Warley, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor. Oh, I apologize. We're waiving count one, proceeding on count two, Your Honor.
Any objection?
No objection, Your Honor. Thank you, Your Honor.
You're welcome. All right, Mr. Warley, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
All right, in count two, you're charged with possession of a controlled substance. Penalty group 1 to 4 grams, that's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Worley, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, the state is proceeding on count 2. Punishment is to be assessed at 8 years in the prison. There's a $2,000 fine. The state recommends community supervision. There's no application for deferred adjudication. There's to be restitution to the lab for testing of $60. TAP evaluation, follow recommendations, and no contact with the complaining witness. Did you understand that to be the plea?
Yes, sir.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
There was one motion that I'd like to address later, but no other motions, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 8 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to count 2, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence?
Yes, Your Honor, state exhibit number 1 with all the attachments.
Your Honor, we've had an opportunity to go over that in its entirety. No objections to the minutes.
All right. Mr. Warley, did you review the waiver and consent to stipulation with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1. Just one moment, I'm sorry. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
I would hope so, Your Honor.
All right, anything, there's something you said you wanted to address.
Yes, Your Honor. This is our first court hearing. My client has been very cooperative with me. My client was arrested on March 25th, 2025, and wasn't indicted until June 26th, 2025, which was actually 93 days later. I submitted a writ for him to be released on a PR bond, but here I am in court, and the state made an offer that my client would like me to follow. He asked me, he understands sometimes you do a PSI, and we were wondering if we could proceed to sentencing. I would hope he would be granted from the bench and allowed to be done all these things while out of custody. He will abide by all conditions, and was just asking simply that.
All right, who's your support system?
My family, my mother and my father, and then I have 2 roommates that I live with that are working for their parents that are working real estate, and as well as joining church. So that is my goal is to get out of the environment that I was in, which this is out of that environment.
All right, and when's the last time you had employment?
Last time it was 2 years ago when I had lost my job at Citibank. It was a work from home job.
Okay.
And then unfortunately, things have happened, and I'm just looking forward to getting started working again, as well as my dad does own his own trucking company. And I was discussing with him the potential of actually helping him manage the books for him.
So not driving.
Not driving, no.
All right, do you have any children?
No, I do not.
All right, so this is what the court is going to do. The court is going to sentence you to 8 years in the prison. Oh, and I'm sorry, state, you may be excused. Sentence you to 8 years in the prison, suspended and probated for 8 years. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home health care provider or with minors. No residing with minors. So when you were using, how often were you using?
I actually do not use drug. I just was in the truck with drugs that were also in the vehicle. So I was charged with possession, but I do not use drugs. I've never failed a drug test ever in my life.
All right. We're gonna do regular random UAs. No residing with minors. There's to be restitution to the Bear County Lab of $60. TAP evaluation out of custody, follow recommendations. If you miss any of these appointments, a warrant's gonna be issued. You understand?
I do understand. That's right.
There's to be 200 hours of community service restitution. And there's to be no contact with the following: Carlos Rene Fernandez, Celeste De Leon, Lucinda Anderson. Oh, these are, they said that there were cards in the vehicle.
Oh,
Okay.
Lucinda Anderson Richardson, Julia Ann Guerrero, Elijah Renee Velasquez, Matthew E. Cox, Jose Luis Nava, Aguinalda Leila Marquez, Michael Scott Torres with a Z, Samuel Garcia, Stephanie Marie Madrigal, Scott Smith, Mercy Trevino, Joseph Gutierrez, Jonathan Little, Jay Richard, Isabella Atcho, Atchoe, Frederick Johnson the third, Matthew Hune, David Lopez, Teresa Olivares, and Jennifer Bianca. Field visits one time per month for 8 months. Probation, is there anything else?
On the names, Matthew. Can you, spell the last name, please?
Hune.
Nothing else.
Is there anything else you need from the court to be successful?
No, and I've actually been, while incarcerated, I've been taking classes and getting contact information for resources once I get released into society to where I can get IDs replaced, and also support systems as far as any type of like food stamps and everything like that, so I can sustain myself and move on.
All right.
So I do have some resources already provided to me.
All right, and with regards to that no contact, there's a restitution to those persons as well. Ms. Ferguson, if I can have a 45-day reset for a restitution hearing? All right, so September 22nd, you'll need to be here. That's to see if there's any restitution. If there's no restitution presented to the court, then there'll be no restitution ordered. All right, we can go off the record in this court. Communication is key when you're on probation. Speak with your probation officer. If you feel they're not addressing the issues you have, you can always come back to court. All right, thank you.
Just to clarify, when you say come back to court, does that mean just like contact the courts or?
No, you're gonna be given a setting and you need to appear in person. All right, and so you should be released from custody probably midnight. All right, and counsel, if there's an issue with this release, just come back to the court and let us know. All right, thank you. Good luck. Yes, you may be excused. Yes, she may be excused. Yes.
I apologize, Judge, I have an ALR at that point.
Okay.
I have asked the office to reach out to his family.
Mhm.
Judge, if we could either come back another time or if you.
Oh, you want to come back
if you
tomorrow
wanna
by
set a
Zoom?
bond and if I get that material that you're requesting, then we can readdress a lowering the bond.
You want to come back tomorrow by Zoom?
I think that's fine, Judge.
All right, we'll see you by Zoom.
Okay, thank you.
You're welcome. All right, who's here on Johnny Galvan?
Ready, Jeff?
Hello. All right, are there any applications?
No, Judge.
All right, the court is calling 2025 CR 0061113, State versus Johnny Galvan. Could I have parties announced for the record?
Jason Garahan for the state, Your Honor.
David A. Garcia, attorney for Johnny Galvan.
And are you Johnny Galvan?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Judge, sorry to interrupt, but I believe there's two cases.
There are two? Okay,
Sure.
thank you.
Yes, sir.
Oh, there is. Also, the court is calling 2025 CR 006603. And in that cause number, counsel, have you received all the discovery as well?
Yes, Your Honor.
Then in each cause number, the court will find that the state is in compliance with discovery. In each cause number, counsel, did you review the true bill of indictment with your client?
Yes, Judge.
And Mr. Galvan, did you review the true bill of indictment with your attorney? Did you understand it? And each cause number, counsel, do you waive the reading of the indictment?
We do, Judge.
State in the cause number ending in 13, which is the drug case, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving count 2, proceeding on count 1 alone, and we're also waiving the enhancement paragraphs.
No, Judge, Your Honor.
All right, and in the cause number ending in 03, the burglary of the building, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving the enhancement paragraphs.
No objection.
All right, Mr. Galvan, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? In the cause number ending in 13, the state is proceeding on the count that is the manufacturing delivery of a controlled substance penalty group 1, 4,200 grams. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. In the cause number with the burglary of the building, the range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have plea bargain agreements with the state in each of these cause numbers, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering these pleas, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in each of these cause numbers?
Yes, ma'am.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
He has, Your
In each cause number, do you believe he has a rational as well as a factual understanding of the charges against him?
He does, and I do.
And each cause number, do you believe is currently competent and was legally sane at the time of the offense?
He is.
Mr. Galvan, in each of the cause numbers, has anyone threatened you, coerced you, or forced you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it and sign it? I'm sorry. In each of the cause numbers, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
And the cause number involving the burglary of the B Hill building, according to the plea, 145 days in the Bexar County Jail under 1244. There's a $2,000 fine. The cases will run concurrently and also concurrently with 2019 CR 13796. And the other cause number involving the drug case, according to the plea, punishment is to be assessed at 5 years in the prison. The state is proceeding on count one. There's a $2,000 fine. There are no applications. They will run concurrent with 2025 CR 006603 and 2019 CR 13796. Did you understand that to be the plea? Defense, is that the plea in each of the cause numbers?
It is, Judge.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph in each of the cause numbers with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
Filed but not heard on, Judge.
Then in cause number 2025 CR 006603, the burglary of the building, how do you plead? Guilty, not guilty, or no contest? And in the cause number ending in 2025 CR 006113, how do you plead? Guilty, not guilty, or no contest? State, in each of the cause numbers, do you have any evidence to support the defendant's plea?
Yes, Your Honor. State exhibit number 1 with all the statements in each case.
You reviewed stage one and all the attachments in both cases that we have.
In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments in each cause number, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge.
All right, and cause number 2025 CR 006113, court will find you guilty, sentence you to 5 years in the prison, give you credit for any time served. This is run concurrent with 2025 CR 006603 and 2019 CR 13796. And the court will request the therapeutic community. And cause number 2025 CR 006603. Court is going to sentence you to 145 days in the Bexar County Jail under 1244. Give you credit for any time served. This is run concurrent with 2025 CR 006113, 2019 CR 13796. There's to be restitution to Renee Rodriguez, Alva, Atalia Hernandez, Alay Hillel, Desiree Mitchell, there's to be no contact with Natalie Rodriguez. All right, and each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because these are plea bargain agreements, because I followed your plea bargain agreements, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, the other cause number, he's not currently on probation, is he?
No.
All right,
Is that a boy?
I think that's the 2019. All right, good luck to you. Thank you.
Thank you, Judge.
Thank you.
Thank you. Perfect. So we'll just. Y'all have a great day.
All right, thank you. All right, can I see the file on Malik Lampkin? Malik Lampkin? He's on Zoom. All right. No problem. Oh, yes. All right, Malik Lampkin,
Yes, sir.
where are you all on Discovery? Hi, Mr. Lampkin, I'm sorry, they didn't have enough room to have you brought over because I'm not the only court that orders inmates. So once they reach capacity, they don't bring any more over.
Right, that's okay.
All right, so where are we on Discovery?
I believe, I haven't been made aware of any discovery that hasn't been turned over, of course.
This is our first course setting, I think we have most of it. I think we should be able to be ready within 45 days if we're gonna be proceeding. I don't know if that's the case. We have talked about working on a global plea because there is an NTR. I think there's something we can work out globally that will resolve all cases. But we're not quite there yet because I think we have a little bit of difference of opinion of the overall result right this minute at the very first court setting. But I think we could get there pretty soon.
All right, he's been set in this court before.
He has, Your Honor. He was previously with a different attorney. This is our first setting. We did file a motion to set bond on one of his cases where he was remanded.
Mhm.
I believe the state agreed to 100 on that.
Yes, and if we want to address, Judge, we
All right,
can.
we'll have to address that.
Yeah.
In the afternoon or either tomorrow. All right, Norma, are you available tomorrow, counsel?
In the morning or the afternoon, Your Honor?
It will be in the morning and it have to be exactly at 9.
I will be in Cornell County
All
tomorrow.
right. So then just set with Miss Ferguson for a bond hearing. All right, Miss Ferguson, if you could put this in September for final discovery and plea deadline. In September. All right, September 22nd.
Your Honor, could I have an associate come tomorrow to work on the bond? Would that be okay?
You have to ask your client if they're okay with that.
Yes, sir.
All right, thank you.
Thank you.
You're welcome. All right, we'll see you tomorrow. Thank you.
Okay, thank you.
All right, everyone, the court is going to take its recess